Now, in today's video, we're going to be talking about the en banc decision in Duncan v. Bonta. This is something that we've been waiting for quite some time. The decision is not a surprising decision. What is surprising is the dissent that was issued by Judge Van Dyke. And to be more specific, the way in which Judge Van Dyke went about doing the dissent. This is something that I think is going to have long-term ramifications. Also, who he was actually generating that dissent for might be interesting. So there's a lot to unpack here. So first off, those of you who are unfamiliar with the case of Duncan v. Bonta, this was originally a challenge to California's standard capacity magazine restrictions. I won't go through the entire procedural history, but many of you have heard of the district court judge referred to oftentimes in our community as Saint Benitez. That is Roger T. Benitez down in San Diego. It was this case that sort of canonized, Saint Benitez. He found that California's California's standard capacity magazine restrictions were unconstitutional. Now, he did this before New York State Rifle and Pistol Association v. Bruin had been announced. So this was when we were still using balancing tests. And he comes up with his decision, which ultimately yields what has been euphemistically referred to as Freedom Week, where during that period of time, people in California could buy standard capacity magazines. It then went before a 3-judge panel at the Ninth Circuit Court of Appeals. That 3-judge panel agreed with Judge Benitez. It said, yes, this was unconstitutional. It then went to an en banc panel. That en banc panel, an 11-judge panel, said, no. Having a ban on standard capacity magazines is perfectly constitutional. It then went to the Supreme Court. It was at the Supreme Court that the court rules in New York State Rifle and Pistol Association, where we now have our, history text regulatory tradition test that's developed, and the case goes back. In fact, goes all the way back to Saint Benitez. He then, again, says that the law is unconstitutional. This time, it bypasses the 3-judge panel, the en banc panel, the panel that is candidly anti-gun, says, no, we don't want to waste our time with the 3-judge panel. We're going to hear this case directly. Now, we already knew how they were going to rule. That was almost inevitable. We knew that after we lose, we will be appealing to the United States Supreme Court. In the unlikely event that the court actually ruled in our favor, we were under no, misunderstanding that the state would be appealing this to the United States Supreme Court. So ultimately, this was somewhat of a foregone conclusion. Now, in the case, the majority says that it's perfectly acceptable to ban standard capacity magazines because standard capacity magazines are not protected by the Second Amendment. Okay, guys, so I'm going to pause this video for just a second. USCCA, which puts on these videos for me, they're doing a giveaway right now. It's very exciting, and you're going to want to participate. It does end soon, so you're going to want to get on this. Now, you can read all about it in the description below the video, but like I said, you're going to want to get on it quickly. All right, with that, let's get back to the video. Keep in mind that the way we look under Bruin to decide whether or not a piece of hardware actually can be afforded Second Amendment protections is first and foremost to start with part 1 of the analysis. Does this law, you can't have standard capacity magazines, does this law abrogate someone's Second Amendment rights? Well, the answer to that question should be yes. Once you've established that, then the burden shifts to the state, and the state needs to show how this law is consistent with our nation's history, text, and firearms regulatory traditions that existed in 1791. Now, the state tried to head this off at the pass, and they were successful. They said, no. The plaintiffs challenging this law, they fail at step one. Their Second Amendment rights are not abrogated because they can't have standard capacity magazines, because standard capacity magazines are not protected by the Second Amendment. In fact, they are nothing more than accoutrement. They're nothing more than ancillary products that really do not control the functionality of a firearm. As such, you can have all sorts of regulatory controls on these types of things. So their decision, I think, is massively misguided. But more importantly, Judge Van Dyke, writing a dissent, decided to do something that, to my knowledge, has never been done before. He did a YouTube video. He actually goes online from his chambers and explains why the majority's decision is, from a firearms standpoint, functionally illiterate. And he uses firearms as a way of describing. He uses them as sort of a show and tell tool. Now, fortunately, Judge Van Dyke, it's pretty clear from his weapons handling as well as his use of nomenclature, the guy's a gun guy. I mean, he knows what he's talking about. And he shows that the state's logic could therefore lead to banning semi-automatic firearms in their entirety, not just magazines, or banning red dots and optics or grips. I mean, essentially, he's able to show while the state's sort of main argument completely fails. Now, like I said, this idea of using a YouTube video is novel. I suspect that it is probably the beginning of something new. I don't think this is going to be the last time that we see either a majority opinion or a dissent actually using social media as a way of talking directly to the people. Now, some of my colleagues are legitimately very uncomfortable about this. You know, there's an argument to be said that, you know, when an opinion is issued, you get the opinion that you can read, and then you get the dissent that you can read against the opinion. When it's a YouTube video, all you're looking at is the dissent, and it's not really giving the other side an opportunity to fight back. It's also potentially introducing evidence that was not admissible at trial. This is an interesting one as well. Typically at the trial court, we make all sorts of ancillary, tools to use to show a jury how things actually went down. At the appellate level, those tools, those PowerPoint presentations, things like that, totally inadmissible because they are not part of the actual record. Now, there's been some talk among my little community that Judge Van Dyke, could potentially be sanctioned for doing this. I don't think that's going to happen. And in fact, the same argument that's levied against us that no, counselor, you can't bring that up, that's not part of the record, would also work in this capacity. The judge could very easily sit there and say, no, I was just simply stating my opinion. I happen to be wearing my robe and I happen to be doing it from my chambers, but I was just simply, informing the public as to my opinion. Again, I don't see this as being a sanctionable event, but I think it is something that we might start seeing more and more of. Now, the last part of this video, though, that I want to mention is who was the intended audience. It might very well have been the Supreme Court. And we'll find this out here probably within the next few days. Many of you have been watching for the cases of Ocean Tactical v. Rhode Island and Snopes v. Brown being granted certiorari, being essentially the court agreeing to hear those cases. And for the last, 9 weeks, every Friday, the court meets to decide whether they're going to hear these cases, and then they subsequently relist them or delist them for the following Friday. So rather than granting cert or denying cert, saying we're not going to hear these cases, they just have been punting week after week after week after week. Well, this fundamental question whether or not standard capacity magazines are in fact protected by the Second Amendment, whether or not the common use test, and that gets into an entirely different level of analysis, but whether or not that is in fact constitutional or being applied in a constitutional manner. These are questions that these two cases could address. And in fact, most likely, if we get the type of ruling from the Supreme Court that we sort of suspect we're going to get, this would overturn the 11-judge panel's decision, the en banc decision in Duncan. So it may very well have been that Judge Van Dyke did this video knowing that there was a higher probability that the law clerks for the Supreme Court justices would see this video and bring that to their justices' attention, and this would then maybe spur them to voting to grant cert in these two cases. If on Monday we find out that they have been granted cert, then, Judge Van Dyke might have played it correctly. In any event, we will have to see. Again, if you have questions for me or, would like to, contact me in any way, you can do so at steven@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.